Hi everyone, welcome to this new episode of the Immigration Lawyers Podcast. I hope you've all been having a great holiday season. Us immigration lawyers had a special Christmas present, the AAO, delivered on the 27th unexpectedly, which was potentially a game changer in the National Interest Waiver EB2C category. The old NISDOT standard has been updated, and the analysis USCIS officers do in these kind of cases has been completely changed. Now, how long it takes for the people up top to notify the officers and adjust the adjudicator's field manual and all that, I don't know. And it's yet to be seen how they're going to be interpreting. But the AAO has already decided some cases based on this new framework. It's a substantial change, and it really opens up the system for entrepreneurs and self-employed people, I think particularly in the business and technology field, who didn't neatly fit into the category for the National Interest Waiver, which a lot of times was for scientists and people with high citation counts, or researchers and professors. Although other people could fit in that as well, that was the puzzle, that piece that fit really well. Now it's opened up, and it's a game changer. I think a lot of my clients, and I've been going through my emails of people who had contacted me about, I'm going to be contacting again, letting them know about this change and how they could take advantage of it. We'll go over that in a little bit. Welcome to the Immigration Lawyers Podcast. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult an immigration attorney for specific information related to your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. So, the EB2C Natural Interest Waiver category is under INA Section 203B2. It's a visa available to, quote, qualified immigrants who are members of the professions holding advanced degrees or their equivalents, or who, because of their exceptional ability in the sciences, arts, or business, will substantially benefit prospectively the national economy, cultural, or educational interests or welfare of the United States. Now, that is the general EB2 category, and normally requires an employer to petition for an employee, for an immigrant, to get their green card. The employer would have to have a job offer and then also request a permanent labor certification from the United States Department of Labor, which is a big hassle and costly process and has all sorts of issues. However, Section 203B2B of the INA allows the Secretary of Homeland Security to waive the requirement for the job offer and the permanent labor certificate. Now, the paragraph that talks about this simply says it should be in the national interest, blah, 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 but it doesn't really get specific, and it's practically an ambiguous term that's never been statutorily defined, which, as the AAO in this new case decision has said, it led to various interpretations. Now, what was the previous interpretation? Well, in 1998, Legacy INS issued a precedent decision to help practitioners and employers and self-employees that are requesting this category. It created a framework which I didn't think it worked well. It's very ambiguous, and it made it very difficult when I was consulting clients because they have a good case and they wanted to have more confidence in it, but I would say, well, the standard is kind of vague and it could always create problems. And I know a lot of practitioners probably won't agree with me, but I prefer doing the EB1A or EB11 extraordinary ability analysis and petition, because at least it had criteria that I could hit and hold the service's feet to the fire about those. Although the Kazarian decision made that a little more difficult a couple years back, I much preferred it, even though it's considered a higher standard. When I did work on national interest waivers, and I'm trying to get angry at other people, I would kind of bring in those categories from the EB1 to at least have something solid to hold on to present. Now, because EB1A has a higher standard, it's not good to merge those, because in the eyes of the officers, it creates a higher standard for national interest waivers, which is not good. We shouldn't create burdens for ourselves that don't exist. But, in trying to really represent my client the best way possible, I try to just use all the tools in my tool belt. But, not directly talking about EB1A, but pushing those points of having articles published, having won awards, having done outstanding groundbreaking work in their field. I would just kind of insert those and just talk about those, and those helped out a lot. But it always, this is one of the categories where I could never feel too strong unless the person had some humongous citation count and really groundbreaking work. Obviously, those are the easy cases. Where the attorney's hard work goes in is those cases that are borderline that we have to do our best. Now, going back to the previous standards set by NISDOT, or as I should say, the matter of New York State Department of Transportation, commonly referred to as the NYSDOT or NISDOT, created a framework that said, one, USCIS would look to see if the petitioner had shown that the area of their employment is of substantial intrinsic merit. Okay. Two, a petitioner had to establish that any proposed benefit from the individual's endeavors would be national in scope. Finally, three, the petitioner had to demonstrate that the national interest would be adversely affected if a labor certification were required for the foreign national. Now, I didn't like the standard at all. It was vague, and as actually the AEO does a great job just tearing it apart and saying, how many years afterwards, 19 years afterwards, saying, what the hell were we thinking creating these standards that are contradictory and go against the whole idea of what the interest waiver is about. The new framework came in the matter of, I believe it's called Dhanasar. The AAO said they believed there needed to be a reassessment of the NISDOT framework and really reset everything. And they said these interpretations had caused problems, essentially saying that cases that should have been approved weren't approved, and they were tired of dealing with the AEO appeal office, having a correct officer made mistakes. And you can't really blame the officers because, they've been giving a bad framework, but, they'd have to spend a lot of time dealing with these appeals. For example, the AEO kind of makes fun of the idea that in NISDOT, a case where a civil engineer was being employed by the Transportation Department of New York, it said that the work they were doing was national in scope because they're dealing with bridges that went to regional areas of the city and of the country, so that made it national in scope. So it kind of is like this game of how could you make this bigger and connected to the nation. Also, the idea of intrinsic merit was vague, and they didn't like that. But more importantly, they said the third prong had issues that really brought about confusion for petitioners, adjudicators, and really immigration lawyers, in that the decision had four different ways to explain what this third prong was. First, the petitioner needed to demonstrate that the national interest would be adversely affected if a labor certification wasn't required. Two, the individual will demonstrate and present a national benefit so great as to outweigh the national interest inherent in the labor certification process. Three, that the individual will serve the national interest in a substantial degree greater than would be by an available U.S. worker having the same minimum qualifications. And four, clearly establishing that the alien's past record justifies projections of future benefit to the national interest. There was also a footnote to that one that said past history of demonstrable achievement with some degree of influence on the field as a whole could be shown and should be shown. Now, the AEO tore this fourth one, or just this general third prong, apart. And one really important one, I'm reading it again, it really stands out. The whole point of the National Interest Waiver was that a labor certification was not required. A labor certification, what you do is showing that no other U.S. worker could do the job, so this foreign person has to do it. Essentially, this National Interest Waiver, which was supposed to put that whole labor certificate aside, is asking for exactly that labor certification by showing that no one else could do that job. So, bravo to the AEO for showing this I don't know, hypocrisy or contradiction, or this is terrible interpretation of how this should be. And secondly, they admitted that with this influence standard that the footnote talked about especially, rested this notion that past success would predict future benefit. But as they said, experience showed that for some talented individuals, past achievements were not necessarily the best or only predictor of future success. So they came around and created this Dhanasar, and I'm sure I'm going to hear from other immigration lawyers what the correct pronunciation is, what they thought will be a standard that has more clarity and is more flexible to advance the purposes of this, broad discretionary waiver. And, there's always going to be problems. I'm happy they did it. I could already see issues popping up, and it still leads to interpretations. But I'm happy that they're thinking about this stuff and trying to do a positive step. So The new standard, as usual, preponderance to the evidence standard for immigration cases. One, that the foreign national's proposed endeavor has both substantial merit and national importance. So they kind of merged the first two prongs of the old one, but they kind of, as we'll go into it, made it less harsh. Two, that the foreign national is well positioned to advance the proposed endeavor, which is very interesting. And three, that on balance, it would be beneficial to the United States to waive the requirements of a job offer and thus a labor certification. Now, all three prongs, especially first two, focus on the specific endeavor that the foreign national proposes to undertake in the U.S. So first, with regards to endeavor, they look at the merit and if it can be demonstrated. It could be in a range of areas such as business, entrepreneurialism. They really repeat this entrepreneur aspect a lot in here, which is hint, hint, they're thinking Silicon Valley, they're thinking tech people, the new medical equipment, just making America great again. Potentially, I don't know what's going on, but it's about this pushing this business angle of just building our market base and our entrepreneurial aspect, and also science, technology, culture, which has interesting culture. They mentioned it, health or education. Previously, culture would work, but it was a hard one. But I'm glad they reiterated it here. On a side note, with regards to entrepreneurialism again. A lot of tech people from India or a lot of business here from China are still going to be facing backlogs. Let me look at actually what the visa bulletin says for the EB2 category for those countries. It might not be that bad. So looking at the visa bulletin right now, all the categories are good. China, it's 2012, India, 2008. So they still have the issues involved with regards to the visa bulletin. But for a lot of these countries, it's going to be a boon. So the AO goes on further to say that evidence that the endeavor has the potential to create a significant economic impact may be favorable but is not required, which is a great line because it does focus on the economic impact of work, which means they're expanding the way they're looking at this towards business, towards people just doing stuff that's going to help the economy and just the U.S. in general, employment, all that kind of stuff. But they said it's not required, so it leaves it in of, they'll go into this later, actually go into this right here. It says like endeavors that further, science and human knowledge on their own could work as well. So if you're working in theoretical physics, things that don't pay off for 100 years, a lot of physicists came up with stuff in the 1900s and we only learned how to monetize it and let it become a mass product or in the consumer world 50, 60 years later after fully understanding the use and be able to translate it to everyday use. So they take those into consideration. Now moving on to the second prong of the first prong, the national importance can be determined by potential prospective impact, having national or global implications within a particular field, such as those resulting from certain improved manufacturing processes or medical advances. So this is cool because, for example, I have a case where, without getting into too much detail, this person's work is groundbreaking, but it's groundbreaking in other areas of the world that are affected by these issues. It's a social issue, a social cultural issue that this person is a professor in and stuff, and it wouldn't really go into the U.S. and Western countries because they've adjusted, but for large swaths of the world, large continents, they're dealing with these issues. And so, it wouldn't arguing, how much would it help the U.S. on a national level? Not that much, but her work is groundbreaking if you're dealing with India and the Middle East and large chunks of Africa and all these places. So the fact that the global implications come into play is going to be very helpful for those kind of cases. They go on to say it's not solely evaluated based on geographic terms. So they take the geographic aspect of the old NISDOT standard and just change it to national importance, which leaves more room to be able to, with good lawyering, explain what this person's work is and how important it is for America, not the contiguous 50 states and within the boundaries, but maybe even more philosophical, thoughtful end of it, which is going to be very good for a lot of different kinds of cases. And they even say ventures and undertakings that have as their focus one geographic area of the United States, it could be properly considered to have national importance. So no more of this saying, okay, it's only going to help your one area. Now, one thing I see when I read the AO decisions a lot, and I read every single one of them when it comes to the employment-based categories and a couple other ones, is people like have high school teachers they request national interest waiver for. Now, God bless them, high school teachers are important, but I don't know what in the world you're thinking just having a regular high school teacher request a national interest waiver. And they get him on the fact that, the poor kid is important maybe as a good teacher, but it only applies to that one school. And I can't really fault him on that. It's I wish we could give anyone who's competent a green card or any person who deserves it, but I mean, just a basic high school teacher that doesn't pass these standards and all that might not be the best person. Maybe they could get the other categories, the EB2 or EB3 category. For a national interest waiver, that's a long shot. And I don't think this interpretation allowing smaller geographic areas as opposed to a national geographic area is going to help them. Finally, they say an endeavor that has significant potential to employ U.S. workers or has other substantive positive economic effects, and again, economic effects, particularly in economically depressed areas, for instance, may well be understood to have national importance. So now it's kind of like an EB5 standard for the TEAs, a lower amount of investment if you're going in a high unemployment area. Potentially, if you're doing something that affects even small areas of land but have high unemployment and have all these economic issues, that could be something that could nudge you towards getting the green card. Now, moving on to the second prong of this new Dhanasar rule or Dhanasar standard, it's a very interesting shift into how they're interpreting the work and the future work. So the second prong shifts its focus to the proposed endeavor from the proposed endeavor, what they're going to do, to the actual immigrant, to see if they're well positioned to advance the proposed endeavor. Before, they would kind of look at what this work is that they're going to be doing, how the work's going to help. Now, the importance of the work is important again, but they look to see if it's realistic, if that person could get that done. Or not realistic is going to get done, actually, and they talk about this, doesn't have to actually get done. But the fact that they're well positioned to do that, which in one sense, it makes sense and it's good, and it's a very interesting way to look at it. Now, there are negatives to this because not everyone could clearly establish that they're well positioned, even though they have a good shot at doing it. But let me go into a little more and parse it out, then we could talk about it, or I could talk about it. So they say by considering factors including but not limited to, looking at the individual's education, skills, and knowledge, their record of success in related or similar efforts, a model or plan for future activities, any progress towards achieving the proposed endeavor, and the interests of potential customers, again, economic customers, users, investors, again, investors. This is big time about bringing in the tech people, just like that initiative, the policy draft or something they issued a couple months ago about entrepreneurs. This is, Mark Zuckerberg behind the scenes, kind of Silicon Valley people pushing the aspect of letting these founder, investor, tech people come to the U.S., which makes sense. Silicon Valley is an immigrant place. Either the people are immigrants or the fathers or mothers are immigrants. So I think this is what they're doing. So showing that you're in a realistic position to realize what the goals of the endeavor are. Now, this kind of changes things. So sometimes, we have a professor that just did good work and they're going to continue that good work. This is kind of saying an endeavor. It's kind of like having a business plan that they wish to realize. It's kind of like an E2L1 or something, or E5, saying this is our business plan that we're going to do. And again, it goes to the economic goals, and I think it's shifting to that. But it requires people to have, some sort of game plan to bring things to market, maybe. That's what they're looking for. It's good and kind of troublesome at the same time. We'll see how it's interpreted. They're probably going to keep the same standards for a lot of other people who are just, academics that do great work, and their great work is just going to continue. And as I said earlier, it could be stuff that's vague and it's going to take a while to happen, which I understand. Because, for example, I have a case where this person's working on this scientific technology with regards to a certain element. And so it's going to take decades for that to happen in reality, but the work needs to start now for it to happen in decades. So, in one sense, the timeline of how long it takes for that technology to come to fruition and become mass marketed, it might happen, but it'll be so expensive, only like NASA could use it, or government military installations, which, that's going to be important actually for military purposes, and we'll get into that. But, when they say customers, customers not going to happen for all investors. There are general investors, but they're pushing this towards business investors and tech, and so I see it. But I think we'll still be okay on the other ones. AO said that they further recognize that forecasting the feasibility or future success is a challenge, that many endeavors may ultimately fail in whole or in part despite an intelligent plan and good execution. So they're saying that we understand this. Now, I have a feeling officers won't be as nice, but they're saying they have understanding. They say they do not require petitioners to demonstrate that their endeavors are more likely than not to ultimately succeed. So the preponderance of the evidence standard doesn't apply for this part, interestingly, which then says, well, what is a standard? But they go on to say they must establish by preponderance of evidence that they are well positioned to advance a proposed endeavor. So I kind of take that back. They're saying that you don't need to show by preponderance of evidence that the endeavor is going to succeed, but they say by preponderance of evidence that you're well positioned to advance a proposed endeavor, which in that sense kind of raises the bar because not everyone's well positioned. They might have great history. I guess maybe if a person, and they'll go into the actual facts of this case, if you have a lot of degrees and citations, that may mean you're well positioned to make this go forward. And when we go into the facts of this case, it'll help flesh this out a little. And after we get done with this third prong, I'll get into that. So the third prong was simplified to require the petitioners to demonstrate that, on balance, it would be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification by evaluating such factors as whether, in light of the nature of the foreign national's qualifications or proposed endeavor, which goes back to the first two, I guess, prongs, it would be impractical either for the foreign national to secure a job offer or for the petitioner to obtain a labor certification. So they're adding this impractical line. They're kind of throwing in the labor certification issue of saying, no other person's working here. They kind of puts that in, but they're talking about impracticability. And I don't really like this prong of it. The other explanations are better for this third prong. Showing what's impractical. I've seen U.S. officers be difficult when we describe how impractical it could be to get certain documents or to prove certain stuff. And I've seen them not showing much leeway on that. But let's go to the second explanation of this prong. Whether, even assuming that other qualified U.S. workers are available, so they're saying even if there's other employers available, the United States would still benefit from the foreign national's contribution, which is great. The whole issue of the labor certification and not finding qualified employment goes out the window. Then they say and, whether, and I wish it said or, but they say and here, whether the national interest in the foreign national's contributions is sufficiently urgent to warrant foregoing the labor certification process. So they're just saying, look at what it is, how important it is. And so this opens it up. So if the person's really doing good work and we could describe it, I think it eases the standard. They emphasize that in each case, the factors considered must, taken together, indicate on balance it will be beneficial to the U.S. to waive the job offer and labor certification requirement. Also, this prong, unlike the NISDA third prong, doesn't require a showing of harm to the national interest or a comparison against U.S. workers in petitioner's field. So this is in general a positive new framework that they've established. So let's go to the facts of this case that caused this decision and analyze it with this new standard. So the petitioner in this case proposed to engage in research and development related to air and space propulsion systems. So, just looking at air and space propulsion, this is kind of a higher end case. It was a good case. I'm surprised USCIS even denied the case, especially when you can see the facts of it, which I'm going to not go into as much detail, but it's related to jet propulsions, military applications. It probably should have been approved under the old NISDOT standard. Not having seen the case or knowing who the person was, I can't really make that decision per se, but it seemed like a good case. So they're developing air and space propulsion systems, and they were going to teach aerospace engineering at the university level. Those were the employments that they were going to take part of. The petitioner there had 2 master's degrees and a PhD. So okay, that's pretty good in the subject of air and space propulsion engineering, that stuff. It was working as a postdoctoral research associate. He'd done much work in the field, had developed models and novel methods of calculations and this kind of stuff. So really, this probably shouldn't have approved. Maybe you could have pulled off an EB1. The petitioner had provided a lot of reliable evidence of his credentials, copies of publications and other articles citing to his work, evidence of membership in professional associations, and documentations regarding his research and teaching activities, along with a lot of letters from people who are established in their fields describing the importance of his work. So as I was talking at the beginning of it, fortunately or fortunately, a lot of those EB1 criteria kind of find their way into the National Interest Waiver. So based on the three-pronged system that was just developed, first, substantial merit and national importance of the proposed endeavor. His work was for military and civilian use and for national security, and they keep saying national security in there, repeated a couple of times. And they had letters, the petitioner had letters from senior academics and government and industry leaders that describe, and I'm guessing had good letters, the importance of the use of this work in U.S. strategic interests. It also included media articles that provided evidence showing how important this field was to the government. So, national security is immediately of national importance and substantial merit. National security, again, national security is probably the way, other than tech, that this is going to get in a lot, which I'm surprised, like a lot of times, it doesn't happen already. Two, the petitioner was well positioned to advance the proposed endeavor. So, he had multiple degrees. He had experience conducting research and developing and doing developments that supported the U.S. Department of Defense, had those detailed letters explaining national interest, and also received government funding before in the past for his project. So it was well positioned, knowing the key players, knowing how the funding system works in the government. Just getting these grants is this whole field of science, really. And he's got them, and he's used them, and he's made these things. So obviously then he's well positioned to advance the endeavor. So before I get to the third one, this was a unique case, and actually I wish all our cases were as cookie cutter as this. But hey, it was denied under an NISDOT standard. If this person came to my office, I would have been excited to take on the case. And I'm sure the attorney that first handled it probably, when it got the denial letter, felt like horrible. I know when I get those RFEs that are bad, it's just this horrible feeling like, oh my God, how did they give us an RFE? This is so good. To get a denial on this with such an established person is hard. And I'm glad they fought it and took it, and they got them to change it and issue a precedent decision, interim decision that's really important. It's going to help all of us. Great work on that attorney that helped in this case. It's great work. So going to the third prong, on balance, they said it was beneficial to waive the job offer and labor certificate requirement because of the multiple graduate degrees that are tied to the proposed endeavor, a record of demonstrating the possession of considerable experience and expertise in a highly specialized field. And it kind of seems that explanations are merging into each other. That's all three is the same, which is the person had a lot of degrees, they had a lot of experience, they created stuff in this field, and they've worked with the government, and they're sponsoring him in national security. So pretty much all the three prongs kind of had the same reasoning, which is kind of weird. But no matter how much they try to create prongs and rules for these very subjective regulations, it kind of just comes out at the end into what they feel in their gut when they first read it. So, but who knows how much help it'll be. Interestingly, on the last paragraph of the decision, they denied the case as to the part where the person says he's going to be a professor, because they said although STEM, science, technology, engineering, math are important disciplines that have substantial merit in the U.S. related to educational interests for the country, they did indicate by preponderance of evidence that the petitioner would engage in activities that would impact the field of STEM education more broadly. So the endeavor, or his role in that endeavor for the education-wise, wasn't in a national interest because it wasn't big enough or big deal enough. So add some conclusionary notes. One is we'll see how well USCIS will adjust to this. And I've seen them issue regulations and fall on deaf ears until there was more pushback, until they had things happen. It could be wishful thinking, but I think this is relaxing the standard. With cautious optimism, I'm excited about this regulation and about actually submitting a petition in this area. I guess if the EB5 petitions go to hell and that's given the new regulations, at least on the other end, they kind of ease this unless the new president comes in. And I think, interim decisions, the Attorney General, or actually I think it's DHS head now, could just shut this down and say, no, redo it. So that could happen. Don't want to be negative. But, if we have these 2 months to file these petitions to hopefully get approved. Unfortunately, national interest waivers don't have premium processing. So it's definitely going to be decided under the new administration. As I said many times earlier, this is really good for entrepreneurs and people who are self-employed and are trying to do cool business and growth in the U.S. Before it more neatly fits scientists and people's citation counts, but it's broad in the field of people that can use a national interest waiver. So I'm glad they're interpreting the national interest more broadly. It's a great idea. I was speaking with someone the other day, and I'm saying the greatest weapon the U.S. has against foreign countries isn't necessarily an atomic bomb, because that just creates more havoc. not these military weapons, but in reality, it's our ability to brain drain the hell out of other countries. You know, I'm Persian, and looking at all the talent that's been sucked out like a vacuum out of that country and come to the U.S., and you look at every single company in Silicon Valley has a founder or one of the first 10 employees, all the billion-dollar ones, has a Persian person in there. So the fact that they'll suck out the great brains in India, in China, in Iran, and so many other parts of the world, it leaves those countries at a disadvantage, and eventually it's going to be a problem having a brain drain for them. But then it puts us in the U.S. at a disproportionate advantage that we have all this knowledge and brain power all in one place, and it's been able to keep us afloat despite all the horrible decisions economically and financially and security-wise and all this kind of stuff that the various administrations have been doing in the last 50 years. It's the people have been really putting things together, and that's really a pro-immigration argument that we need to keep these walls down and the gates, not open, but having a good knowledgeable guard at the door that could help people that I mean, it's interpretation but I think we should be here, and it could help us and it could adjust life in the U.S. and bring some positives with them, and always there's be negatives as well. Everyone has both sides. In the U.S. there's negatives as well, so we can't think of some angels people coming in, but it's a good way, especially this National Interest Waiver, to get the best, and why not, Now, moving on, now the need to focus is more on the ability to succeed rather than having an idea that on its own is going to succeed or is like a surefire, business plan that's going to succeed. So that's really good. As I said, self-employment is going to be much easier. People are self-employed kind of fields. It's going to be much helpful. And, people doing work for the Department of Defense, they've already been using this, but it's going to be help out a lot for people working on various engineering and physics and those kind of fields related to military application. It's going to make the U.S. Nationally competitive, and it's going to be an important factor. That's what they're going to look at. How it's going to help the U.S. to compete in the 21st century. And I think that's a good way to do it. The National Interest Waiver, the EB1, those are the top-notch ways. EB5 potentially is a way of doing that. It's hit and miss. Sometimes just some rich people that probably scammed their way to money, but then there's some people who are really good candidates who earn their money, and then they did it through hard work and business sense and education and just doing great work. So these employment categories are great. They need to be used well, but we got to work on making these easier, frankly, less of a hassle. The new administration is going to have problems with the Department of Labor for EB2 and C categories, but that's where these national interest waivers, where they waive the Department of Labor certification, will be helpful. But I think if the pundits learn that there exists a thing as a national interest waiver where the labor cert is waived, they might jump on it and create a big hubbub. But this is a good example, actually, this case, because the person is working for DOD, Department of Defense stuff with NASA, jet propulsions. When they're challenging it, immigration lawyers will say, hey, wait a minute, the person doing this was helping our national security. So usually the same people who are pushing, like fences and borders issues are big, sometimes neocons, sometimes big war military hawks. Because, hey, listen, it's going to help that aspect, and it might, calm them down a little. We'll see. It's sometimes hard to calm down people who are too mad. But thank you for listening. I'm excited about using this program. I'm going to be probably filing a couple of cases in this very soon, especially cases where I was on the fence on. I think this lowered the fence and made it easier to hop over. So I'm going to give it a try. I hope you guys enjoyed this podcast and this episode of the Immigration Lawyers Podcast. Please go and subscribe and follow on iTunes. Watch on YouTube, leave comments on YouTube, Immigration Lawyers Podcast. And also, if you're an immigration lawyer, contact me, info@jqqlaw.com, if you have opinions, questions, issues. And also to join my listserv, the immigrationlawyerslistserv.com, where you could trade information, exchange information, and help our colleagues to better function and be successful in our field. Thank you so much.